Well, hello again to the Employment Law Show. Welcome. John Scholes right beside me. As you can see, Lior Samfiru, employment lawyer at employmentlawyer.ca. Right off the top, every week I tell you to reach out to Lior and his team if you have any questions. You need a good employment lawyer to help you through those murky waters of dealing with your workplace and with your boss. It starts with a phone call, right? 1-855-821-5900. Help at employmentlawyer.ca is also another way to reach Lior. Back it up with an email and a phone call. Take it from there. We'll give you some more contact information, other ways to reach out throughout the half hour as we roll on here. Lots of good things to get to. We'll get to a bunch of calls from one of our radio shows across the country, your emails, and always a main topic. And this week it is the risk of misclassifying employees as contractors. Big risk, and we'll open up why momentarily. But Lior, we always get into the week that was to kick us off, pal. This week we'll do the same thing again. What do you got?
Hey, John, great to be here. It's such an important topic for us to cover on the show. That's why we've been able to do it for so long. There's so many things to cover, and I speak with people every day, whether it's by phone or email, and they have questions, they have issues. There's a lot of issues that could impact your job. Maybe you're being burnt out, you're stressed out, you need some time off work. Well, how do you deal with that? I talk to people about that all the time. Maybe you have a boss that's not treating you properly and you need to have that issue resolved. Well, guess what? The law can take care of that as well. If you lost your job, the law has options, they have rights. So that's why we have this show. And one of the things you will know more about when you watch the show is that very important aspect of your life, your job and your rights. But this is only 30 minutes. John, I wish we could do this for longer and cover even more. That's why I say contact me after. We can have that private chat or private email exchange if your issue hasn't been addressed or if you want me to help you actually resolve that issue. But I always like to start off with a case that came across my desk. John, I spoke with a lady who was put out of nowhere on a performance improvement plan. From her perspective, everything was going great. She gets called into a meeting, though, all of a sudden, handed this 3-page document as essentially being told, you're doing all these things wrong, and we're putting on a performance improvement plan. We're going to give you 3 months to do better or else. This, again, as I said, came out of the blue for her. From her perspective, things were going well. She always exceeds expectations on her review. She's been there for a long time. So she was very confused and, of course, very upset, as one would be. So she contacted me, and it really seemed far-fetched what her employer was saying. They were nitpicking on nonsense things. And the thing that jumped out at me is she was never actually given an opportunity to know about those issues before they just went ahead and put on a performance improvement plan. So what I told her to do is I wanted her to write back not just to her employer, to the boss that put her on a performance improvement plan, but also to the HR person, to copy the HR person and say, here's why I don't agree with the performance improvement plan. And I'm also disappointed that you just put me on one and you didn't give me a chance to do better by just talking to me. So she sends that email. Guess what happens here? The HR person reviews it and says, yeah, you're right. This shouldn't have happened. So the manager actually ends up getting disciplined because she really made a mistake. She didn't deal with this employee properly. So this performance improvement plan is gone now. The manager was disciplined and things are back to the way they should be. There's an important lesson here. In the face of a performance improvement plan, don't be silent. You cannot be silent. Your silence is the same as acceptance. Do what this person did. Respond. Say why you don't agree with it. By doing that, you're preserving your rights. You're preserving your job potentially, and good things can happen. If you're not sure how to respond, give me a call, but never be silent in the face of an unfair performance improvement plan.
If there's the time of that performance improvement plan, Lior, where it simply says sign, sign back that you've received this, is there any fear? Is that seen as acceptance, or that's just saying exactly what it's saying? You've received it. I don't necessarily agree with it, but at least I've seen it.
Yeah, in the vast majority of cases, you're asked to sign a performance improvement plan. It simply says, by signing here, you acknowledge that you've received this and you understand what it says. There's no issue with signing that. You can sign it, it's fine. Now, if it says by signing here, you're agreeing that all of this is correct, well, you cannot sign that because then you're agreeing. Usually you wouldn't do that. So in most cases, it's okay to sign it as long as you respond to it later, as I've said. But if you're not sure if you should be signing it or if somehow that can be held against you, that's why I'm here and that's why you call me.
Is this always a precursor to being fired? Usually when you see these, they're trying to build up a case, as you've been saying on the show for years, to get rid of you, yeah?
That's what it is. You know, if an employer wants to let an employee go for a cause and not pay them severance, one of the ways they try to do that is to build up that case, to show, well, we've warned the person, we put them on a performance improvement plan, what more can we do? So that's why it's important to respond to it, because if you don't, you're just playing into the employer's hand. You're going to let them potentially fire you for cause, or give yourself a weak defense to that. So respond to it and preserve your rights, preserve your job.
So if I'm an employer now, if we turn the tables a little bit, Lior, for a moment, if I'm an employer, how do I approach using the performance improvement plan with an employee? Because this one obviously just jumped the gun right away and slapped it on her desk and ended up getting slapped for it. But how do you navigate that as an employer?
So as a performance improvement plan, you have to remember that it's a tool that's not used just because the employee did something wrong or because the employee is not doing a fantastic job. Before you do that, which is a fairly serious measure, talk to the employee. Tell them, here's what we want you to do. Here's what you can improve on. Give them that opportunity. If they're not able to do that, if you've tried it, nothing has happened, then you can use that performance improvement plan. So you want to have that as a second step, not as a first step. But within that performance improvement plan, you also want to stipulate, if you're the employer, what you're going to do to help the employee. It's not enough to say, here's the problems, do better. You have to say, well, here's the issues, and here's what we want, and here's what we're going to do to support you to get there. So you have to do those things. If you don't do those things, you're probably not dealing with the employee in good faith, and that's not good.
Again, as I mentioned off the top, Lior and I have been doing radio shows for years and years across the country, several provinces, and an opportunity always for you to join us on one of those radio shows. Simply go to employmentlawyer.ca to find a radio station near you that carries the show. We get a lot of great phone calls every week for sure. We play them back here, Lior, because it's always a learning tool for us as we break them down. Let's get into phone call number one now. Listen up.
My employer had a meeting asking us to cut back our hours from 40 hours to 30 hours. I said, unfortunately, I'm not going to be able to cut back my hours. Then today, they handed us a letter and said that we are now temporarily laid off.
How long have you worked there for?
2 years.
And what kind of a job and how old are you?
I'm 55 and I'm office administrator.
All right, break that down for us, pal. Where's the problem spots?
Well, there's many of them. First of all, of course, they did not have a right to reduce her hours from 40 to 30. That's a constructive dismissal. That's a big change to the terms of employment. If your employer makes significant change to the terms of employment, you could treat that as a termination and force them to pay you severance. Well, this employer said, they saw that and they said, well, we know we're not allowed to do that, so let's do something else that's illegal. They put her on a temporary layoff. Remember, for most people, the answer is you cannot be put on a temporary layoff. If you are, that is a termination. That's a 100% reduction of your pay. So for her, once they put her on a temporary layoff, she can treat that as a termination and get severance. So now all that's left for us to do is figure out how much severance she's owed. For that, we're going to go and use our severance calculator tool. You can find that at pocketemploymentlawyer.ca. And let's see how much severance she's owed. She's been there for 2 years in an office administration position. She's 55 years old. Company's not paying severance. They don't know they have to, except you see right there, she's owed as much as 4 months of severance. 4 months, even though she's only been there for 2 years. That's how that works. That's why you can also go to severance to the severance calculator. Just check out pocketemploymentlawyer.ca.
You know, that's interesting where it says 2 years worked, 4 months severance. Most people seeing this now would say, well, no, 2 years. Week per year, 2 weeks per year, maybe 4 weeks on the high end, Lior. Why 4 months, right?
Yeah, and those are all misconceptions. They're false. It's not a week per year or 2 weeks per year. There's several factors that go into assessing severance, and the net result is that for most people, if not for all people, the amount of severance you're actually owed is a heck of a lot more than a week or 2 weeks per year of service. People are surprised. Sometimes the length of severance can be more than the length of employment. That's why you go to pocketemploymentlawyer.ca or call me, because you'll be surprised by just how much the law says you should get.
All righty, phone call number one done. Let's get into phone call number two. Lior, listen up.
Good
working for a company for 20 years. The company gets sold. It's a private company, non-unionized, and it gets sold to another owner. Can they offer me a severance package prior to the new owner taking ownership? If so, would that be mitigated by the fact that I have the same job guaranteed with the new ownership?
Great call.
So it's a great question. So what happens on a sale of a business is if you're offered a job and are accepting a job with the buyer, then your employment is actually not terminated. So your employer, your old employer, does not have to pay you severance. They don't have to. Right. The new company inherits the service and you continue working. So if the old company is offering you severance, it's really a gratuitous payment. It's not something that they're required to do. So if you want to accept, because otherwise you won't get anything. What's important to remember is the new company, the company that bought the business you continue working for, they inherit your service. So down the road, if they let you go, they have to account for the previous service you had. You want to be very careful when you accept the job with the buyer, not to sign an employment agreement that changes that limits that, or that says we will not look at past service. That's extremely important. So if your business is being sold and you're staring at that job offer from the buyer, please do not sign it before you speak to me first.
Does that severance calculation and who pays the severance, Lior, change if you're not offered a job from the new buyer? It's like, oh, thank you for your service. Out you go, we don't need you. And then at that point, do you get severance? Who has to pay it?
So if as a result of a sale of a business, if as a result of that you lose your job, you're no longer going to be employed, then the old company, the company that's selling the business, has to pay you your full severance. That, of course, could be as much as 24 months pay. So if you lost your job, old company pays severance. If you don't lose your job because you continue with the buyer, that buyer inherits your service.
All right, we do phone calls in threes. We'll do the third one on the other side of the break, and then we'll get into our main topic as well. So lots more to go here on the Employment Law Show. Stay with us. We are coming right back.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Employment Law Show. Lior Samfiru and his team always standing by to assist you in your workplace matters. Just reach out with a phone call and email. How about that? Phone call 1-855-821-5900, help@employmentlawyer.ca. Let's get into our third phone call. I want to remind you as well that across the country, various provinces and times and hours, Lior and I are always on the radio somewhere, and you'll always have an opportunity to call in as well. Go to employmentlawyer.ca to find a radio station close to you where you can join the show on the show, or at least your voice will appear anyway. Let's get to phone call number 3 now. Lior, listen up, pal.
On behalf of my daughter, she has a doctor's note. She needs to have some restrictions to her job. The employer first agreed that they would accommodate. When she provided what she thought was the best answer for the accommodation, they refused, basically telling her maybe she shouldn't work in the field of work that she's in. Would that be constructive dismissal?
What do you think?
Well, it's illegal. Let's start with that. An employer has an obligation to accommodate. It's one of the most important obligations that an employer has. It's under our human rights code here in Ontario, and every province has its own human rights legislation that requires an employer to provide accommodation if the employee has medical restrictions. That's not something that the employer gets to decide to do. They don't have a say in it. If they're able to at all to provide that accommodation, they must provide it. Now, it's only in situations where the accommodation is so over the top or so expensive that the employer may be able to say, well, I just don't have to go that far. But in the majority of cases, when your employer is provided with that doctor's note, they have to accommodate. And if they say no, they're probably doing something illegal. They're probably breaching human rights laws. So if this employer got that doctor's note, they had to accommodate, and their failure to accommodate is illegal. That does also result in a constructive dismissal. If your employer is not giving you the support and accommodation that you need, not only is it a human rights violation, it may also allow you to treat that as a termination and get severance. So employers must take this seriously. And if you've gotten that doctor's note and your employer doesn't care, doesn't follow it, doesn't believe it, wants you to get more medical information or wants you to get another opinion, none of that is legal. You got to give me a call. Usually, once they hear from me, things change very quickly.
Does the doctor's note or medical backing, is that what triggers the accommodation? Like, you can't just walk in and say, I can't lift 50 pounds and I need a new desk. I mean, you need something more than that, yeah?
Correct. Yeah. An employer is absolutely able to insist on some verification from a doctor. Now, you may go into your employer and say, I can't lift more than 50 pounds. And maybe a good employer is going to say, yeah, we'll accommodate you. But if the employer wants a doctor's note to verify that, they're allowed to get it, and you should get it, because it's the doctor saying that imposes that legal obligation on the employer. So that doctor, having that doctor in your corner, supporting you, is the trigger that you need to start that accommodation process.
Is there, Lior, is there a threshold or level of accommodation based on the employer? Meaning, Joe's coffee shop in the corner doesn't, or wouldn't be expected to do as much as a big multinational corporation with thousands of employees. Would that be accurate?
Listen, if you work for a tiny company or organization, there's only one other employee, there's not a lot of jobs or resources, it's going to be tough potentially for that employer to accommodate. There's just not a lot of options. But if you work for a major company with lots of jobs and lots of options and resources, man, it's going to be really, really tough for that company to say, oh man, no, this is just too difficult. We don't have to go that far to accommodate you. So yes, the type of company, the type of business and industry is certainly a major consideration in determining whether a company should accommodate. But I can tell you, John, across the board, across all industries and frankly all provinces, I see this all the time. Companies saying, oh, no, we don't want to accommodate, when in fact they still have that obligation.
All right, let's move on to the main topic for this show. We have one every week, and this week it is the risks of misclassifying employees as contractors. Back to basics, 101 contract talk here, Lior, and that is, what is the definition of an independent contractor? Break that down first.
Extremely important, because guess what, John? Most people are misclassified. They're not independent contractors, even though they may think that they are. An independent contractor is someone that's in business for himself or herself, someone that runs a business with customers, with clients. They provide services to their customers, and they have various customers. They're trying to get more customers. They're running a business. An independent contractor is not someone that has one company that they work for 40 hours a week. That's never going to be an independent contractor, because you're not running a business. So you're a plumber. Your plumber is running a plumbing business. He has several customers. He manages his own schedule. He needs to know where he's going to go to fix the issues. So if he comes to your house and fixes your plumbing issue, he's not your employee. He's going to go off to the next customer and run the business. So that is an independent contractor. But if that plumber came to your house every day and only your house and worked for you 40 hours a week and that's it, then that person will become your employee. And too many times, John, people are misclassified. They think that it's enough to just say, hey, I'm a contractor, or for the company they work for to say you're a contractor, and that somehow makes them a contractor. That is not the case.
So why do companies misclassify employees as contractors?
Well, because it's a lot cheaper to have a contractor than to have an employee. If you're a contractor for real, then the company doesn't have to pay into EI or to pay into CPP. They don't have to withhold anything off your pay. They don't have to comply with vacation pay and minimum wage. It's a lot cheaper. So companies sometimes say, well, I want to save money. I know how to do it. Let's just call this person a contractor and I'll save a bunch of money. Except guess what? The law is a lot smarter than that. If it was that simple, that anyone could do that. And clearly that's not the case. So if you're misclassifying, both you and the company are taking risks. CRA may knock on the door one day and say, no, you weren't really a contractor. You owe back taxes, penalties, EI, CPP. Don't do that. If you're an employee, act and call yourself an employee and make sure you don't do it wrong.
Can the employment contract, can that nail down someone's status as an employee or a contractor?
So just because you sign a piece of paper that says I'm a contractor does not make you a contractor. Otherwise, again, everyone could do that. Just sign something and all of a sudden you magically become a contractor. No. The only one that can determine if you're a contractor or the employee or an employee is the law. So if you look like an employee and act like an employee, you are an employee. It doesn't matter what you sign. And I want you to take this kind of final thought here. Too many times, independent contractors who are not really independent contractors are being let go from their job. And they assume, well, I don't get anything because I was a contractor. I don't get severance. But guess what? You're probably an employee, which means you do get severance. That could be months and months and months of pay. So at a minimum, if you believe you've been misclassified and you lost that job, call me because you're still going to be owed your full severance.
Well, then, yeah, I mean, at the end of that, that's a great point. Someone gets misclassified, they're let go. They're assuming they don't get severance, and they walk away. They shouldn't be because it could be, as you say, up to 2 years severance, right?
That's exactly right. I've spoken with hundreds of people over the years that just knew for a fact, or at least believed that they're independent contractors. But when they called me, they realized, no, they're not, and they're owed severance, and we help them get severance, and it's not even complicated. So independent contractor or an employee, you do the same thing, you call me. And by the way, if you're not sure if you're a contractor or an employee, we have a tool for that. Go to pocketemploymentlawyer.ca, click on the independent contractor tool, just answer a few questions, and you'll find out if you're an employee or a contractor.
We are going to our website, terminationquestions.com, for your next question after the break. We'll get to that as we continue more of the Employment Law Show. Don't go anywhere.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, thanks for hanging around for that short break. Employment Law Show continues. Again, I mentioned it before the break, terminationquestions.com, yet another place for you to ask questions for Lior and his team. It's free, it's anonymous. So this week, Lior, here we go, and here it comes. My girlfriend is returning from maternity leave after 2 weeks of planning a return. Her company told her they no longer have a role for her. Should we speak to a lawyer? We thought her job was protected. Data analyst earning about $70,000 a year and has been with the company for almost 4 years. Bit of a pickle, pal. What do you think? What does she do?
So yes, for the most part, John, if you're on a parental leave, your job is protected. We call that a job protected leave. So for the company to now say, oh, we don't have a job for you, they have some splaining to do, as they say. And what I mean by that is they have to show why. Did you go through a major restructuring? Did you cut down the department? They can't say, well, we just gave the job to someone else. No, that doesn't work because your job is protected. Now, if something major happening, major restructuring, and the job doesn't exist, they don't do it anymore, then at that point, and only at that point, are they allowed to terminate with full severance. But in most cases, if your employer won't bring you back from parental leave, that potentially is a breach of the Employment Standards Act. It's a human rights violation, not to mention a termination as well. So very, very illegal, and you should always speak to me if that happens to you. Of course, the last thing we want to do here is, even if the termination was legal, which it's probably not, but even if it was, how much severance is this person owed? We need to figure that out. So we're going to go one more time to the severance calculator. You'll find that, of course, at pocketemploymentlawyer.ca. Let's do that right now and see what we get. So as a data analyst, 4 years there, making about $70,000. We think that the company offered minimal severance. We see that this person is owed 4 to 6 months of severance. 4 to 6 months. That's why it's important to go to the severance calculator, because you're going to be surprised by your entitlements. It's free and anonymous. It's there for you. So check it out.
Okay, you can always join Lior and his team as well. They also do live streaming. So busy, this guy. He's all over the map. But live streaming happens on YouTube and Facebook. You want to tune in at ST Lawyers, to join that chat. Here's the question for today, Lior. I was moved to another department against my will, which cut my commissions by more than 20%. I complained, and a week later, I was fired. Is this a reprisal?
So it's a constructive dismissal, yeah, and absolutely could be a reprisal as well. So that cut to your commission is obviously a big change to the terms of employment. If you're a commissioned person, anytime your commission is taken away, restructured, cut down, that could easily and will easily impact your compensation. And once we're talking about impact of compensation, constructive dismissal, illegal. And if you go to talk to your employer and they say, well, you raise concerns about constructive dismissal, so we're letting you go, that's a reprisal. You're being punished for asking about your rights or standing up for your rights. That's not legal. So yes, this employer would have done things wrong on both fronts, constructive dismissal and reprisal. You should always feel comfortable advocating for yourself and your rights. And if you're not sure how to do that, or if you've tried and you got punished, that's why I'm here. You have to call me in that situation.
Again, that phone number, 1-855-821-5900, help@employmentlawyer.ca. We always wrap up the show with our favorite part, that's employment rights rapid fire. Let's get to that right now. All right, here we go. The questions we throw at Lior. I got the easy job, pal. I just ask him. You got to answer them. Concise and quick. Number one is this. Can an employee be forced to accept a demotion?
In most cases, the answer is no. A demotion is a big deal and could result in a constructive dismissal. Remember, if you refuse, you can be let go, but with your full severance. So if that's your situation, you got to get some legal advice.
Rapid fire question number two is this, Lior. Can an employee resign and still receive severance pay? Is there a situation where that happens?
So if you're resigning because of something that your employer did, something bad, a reduction in pay, mistreatment, change in your hours, and that's why you resign, that's a constructive dismissal and you still get severance. Or if you resign because you were threatened into resigning. So those are exceptions to the rule. So again, if that's your situation, I would still rather you talk to me before you go ahead and resign.
Rapid fire question number three for this week is this. Can an employee be denied vacation pay? I guess vacation pay, vacation time, they're different, yeah?
That's right. So in some situations, an employee can lose vacation time if they don't take it, but you cannot lose vacation pay. Even if you haven't taken your vacation, you have to get paid for that money. So you cannot lose that amount ever.
Can an employee refuse to work overtime?
So yes, an employee in most cases is able to refuse to work overtime and cannot be disciplined unless, of course, you sign an employment agreement where you explicitly agree to work overtime whenever you're asked. So look at that employment agreement, and you can otherwise absolutely say no. And of course, you have to get paid for that overtime, time and a half, if you work it.
And even if you worked it and were told not to, still got to get paid, right?
Correct. With respect to overtime, if you did the work, you have to get paid no matter what.
Okay, one more rapid fire question for this week, Lior. Here we go. Can an employee request to work remotely permanently?
Well, the only time you can actually insist on that is if you have a doctor's note and there's a medical reason for it. If there's a medical reason and your doctor says you need to work remotely, your employer must accommodate you. But again, it all starts with that doctor's note.
And that is it for this week. That is it for Rapid Fire. Thank you so much for joining and contributing. If that was your email or question, always reach out to Lior, 1-855-821-5900, help@employmentlawyer.ca or pocketemploymentlawyer.ca, only website you need. Thank you so much. We'll catch you next time on the Employment Law Show.